Hello, my name is Dan Smith, and I'm going to be interviewing Arthur Evans today about the Set Law Lie, Proposition L. Arthur, can you tell me something about yourself and why you're interested in this particular problem?
Dan, thank you for giving me a chance to discuss Prop L, the Sit-Lie Law, or the Civil-Sidewalks Law, which will be on the ballot in November in San Francisco. I'm a self-employed, struggling writer. I'm a tenant. Next month I will be 68 years old, and I support this law because of my personal experiences living in the Haight and in San Francisco.
Well, I've heard this thing about Proposition L is that it's criminalizing a victim class, which is the homeless, by making it illegal for them to sit on the street.
Yes, that's an objection that has been raised by critics of Prop L, and in fact, it's mistaken. Prop L does not criminalize sitting on the sidewalk. Prop L provides that if people are blocking the sidewalk, that is, sitting or lying on the sidewalk, in a way that is inappropriate, the police have the authority to tell them to move along. As things now exist in San Francisco, the police cannot do that. If the police see people obstructing the sidewalk, they cannot legally tell them to move along. And the law provides that for first offenders, there will be a warning only, no citation, no prosecution. Furthermore, the law specifies a number of exemptions, such as people with medical problems, mobility problems, and other exemptions as well.
Well, another problem that I've heard from the community is that we shouldn't be making propositions which are unconstitutional, and it appears to them that it's unconstitutional. Can you refute that?
I agree that we should not have propositions that are unconstitutional, but Prop L, the Civil-Sidewalks Law, is constitutional. Let me tell you why. The Ninth Circuit Court of Appeals, which is a federal court whose jurisdiction includes San Francisco, ruled that a similar law in Seattle was constitutional. Our law here, proposed law, is based on the Seattle law. Furthermore, the United States Supreme Court has never ruled that people have a constitutional right to squat on sidewalks. In fact, the opposite is true. The sidewalk should be free and open for everyone to use. Nobody should have a right to move in, take over turf on sidewalks, and cause a problem for other people.
Well, you know, why do we need this rather stern law when no one else, anywhere else, seems to have it? Why is the problem here?
In fact, a number of other cities and localities do have it, but San Francisco has a special problem. And that is, because of the nature of regulations and court proceedings here, the police cannot, acting on their own, tell people who are blocking the sidewalk to move along. To the best of my knowledge, San Francisco is the only city in California that puts this restriction on the police. And Paul Henderson, the Assistant District Attorney for San Francisco, prosecutes obstruction of sidewalk laws in San Francisco. And he has testified to the Board of Supervisors that the procedures here in place prohibit the police from telling people who are blocking the sidewalk to move along. And what this law does is it gives the police the right, if they see someone blocking the sidewalk, to go up to them and say, you have to move along. And as I said, the first offense is just a warning. So if San Francisco were like other cities and allowed the police to act on their own initiative when they see people blocking the sidewalks, we wouldn't need Prop L. But, you know, San Francisco is a special city.
I see. Well, isn't Proposition L really an attack on the homeless?
No, that is absolutely false. If you go up and down my neighborhood, which is the Haight Ashbury, and you talk to people who are on the sidewalks, they will tell you, quite frankly, that almost all of them are from out of state or out of city. Very few people who are called homeless in San Francisco are San Francisco residents who have become homeless. What we have here in San Francisco is we have large numbers of people who are nomadic addicts and alcoholics. They swoop into the city in search of easy access to drugs and lax law enforcement, both of which are characteristic of San Francisco. And what happens is they engage in a host of illegal activities which undermine the neighborhood. For example, urinating and defecating on the sidewalks, selling drugs, harassing passersby, having their dogs, their pit bulls, bite and attack residents, stabbing each other, sometimes to death, leaving used hypodermic needles in the sandboxes of children, setting fires, destroying public parks. All these activities are matters of behavior, and this law is designed to regulate and control behavior, not the status of being homeless, because there are homeless people who do not engage in these activities. The purpose of the law is to contain toxic behavior.
But isn't the result of the law is that perfectly innocent homeless people, like the little old lady that is down the street that sleeps outdoors, she's not going to be harassed by the police. So she has no behavioral problem other than that she can't take care of herself. What happens to her when she is told to move and she doesn't because she just doesn't have the ability?
San Francisco, in the 7 years that Gavin Newsom, nearly 7 years that Gavin Newsom has been mayor, has spent $1 billion on social services to the homeless. There's an article about this that appeared in the September 27th, 2010 issue of the San Francisco Chronicle. And what this points out is that San Francisco, for example, last year spent over $300 million on services to the homeless. What we have in San Francisco is a large number of people who refuse services, repeatedly refuse services, and in fact threaten people who provide them with services. So the problem in San Francisco is that we have an abundance of services, but almost no restrictions in terms of accountability. And that has created an imbalance. In effect, San Francisco has become the service provider of last resort for the homeless people of the United States. No city has the resources to do that. We have to restore balance, and balance means accountability as well as services. So the homeless person who is on the sidewalks and has no place to go should go and access the public services that many refuse. They're there. I live in the Haight Ashbury neighborhood. We have one of the highest concentration of social services for the homeless of any neighborhood in the city. And I repeatedly see people refuse services and threaten people who offer to make them. This situation is intolerable and has to be corrected.
Well, there are already laws on the books that dealing with these particular offenses, and there seem to be sufficient every place else in the state.
That's a very good question, Dan. Thank you for asking it. It really goes to the heart of the matter as to why we need the SIT-I law, Proposition L, the Civil-Sidewalks law. The existing situation in San Francisco is blind to a reality of life, and that reality is turf-taking and territoriality. As I mentioned, we have packs of migratory addicts and alcoholics who've come into San Francisco in search of drugs and lax law enforcement. They occupy public places, which they take over as their turf, their territory, and they use it as a basis for going out and committing these crimes. Now the problem with the crimes that you've mentioned is you have to have a victim before you can prosecute. You have to wait until somebody is stabbed before you can arrest somebody for stabbing them. You have to wait until somebody urinates or defecates on the sidewalk until you can arrest somebody for that. The SIT-I law, the Civil-Sidewalks law, realizes and acknowledges, frankly, that there's a territory issue here. People come in and take the territory which they use for their own personal purposes. And because of existing laws in San Francisco, the city can't do anything about that. This law will change that. Can I give you an analogy, Dan?
Certainly.
Let's consider the oil leak that occurred recently in the Gulf of Mexico. It was a terrible catastrophe, damaging to the environment and to people, and just dreadful. Why weren't precautions taken ahead of time to keep that from happening? Well, the same thing can happen here. Why do we have to wait until people are knifed, until people get jabbed by used needles, until people get bitten by pit bulls, until there's human waste on the sidewalk? Why do we have to wait until there's injury or damage? Why don't we take a simple precautionary step of recognizing turf taking is taking place? Let's challenge the turf taking itself. Other cities can do this because they don't have the restrictions on the police that San Francisco has. Let's bring San Francisco in line with standard practice and recognize the reality of turf and the reality of the geography of incivility.
Well, you know, there's this Proposition L, which is the foot patrol measure to
That's
increase...
Proposition M, actually.
Sorry, Proposition M, the foot patrol measure. Don't you think that would be sufficient to increase foot patrols?
Proposition M, which would create more police foot patrols in San Francisco, started out as a very good idea. I supported that measure. I supported both Prop L and Prop M. Unfortunately, the politicians at City Hall played a game.
Who were they?
Those politicians are David Chu, a member of the Board of Supervisors, that's our city council, and Ross Mirkarimi, a supervisor. What they did is they put a poison pill into Prop M. The poison pill provides that even if Prop L is approved by the voters, it will be null and void if Prop M gets more votes. So what happens is you have one proposition determining the conditions of approval for another proposition, which is totally absurd. That was a manipulative ploy by Ross Mirkarimi and David Chu. And in fact, by doing that, they made it impossible for people who want to support both measures to support both. So under the circumstances, in the face of this ploy, if you want to improve the quality of public life in San Francisco and make the streets safer, the solution is to vote yes on Prop L and to vote no on Prop M. If you vote for both of them, you may be cutting yourself off at the knees if you want to approve Prop L.
You're very knowledgeable. Now, I was opposed to the set law lie, probably still am. However, your arguments are very convincing. Do you have any other conclusion? Do you have any conclusions?
Yes, I do, Dan. This law is very mild. It provides for a host of exceptions. It provides for a warning only on the first account. And if approved, it will make our sidewalks safe and accessible for all people. And it will put a clamp on the bullies who are occupying territory and squatting on the sidewalks and abusing them as their own turf. The opponents claim that this is an attack on civil rights and a violation of human dignity, and no such thing is the case at all. What we want is a simple, mild law, which this is. It couldn't be any milder. So I ask you, please, vote yes on Prop L, vote no on Prop M, and I thank you, Dan Smith, San Francisco artist, for giving us a chance to discuss this issue.
And thank you, Arthur.